and welcome to Civil Bytes. In this video, I'm going to explain relation between fundamental rights and directive principles of state policy. Fundamental rights, also described as Magna Carta of India, they are enshrined in the Part 3 of the Indian Constitution. They are enforceable by law, which means if your fundamental rights gets violated, you can file a petition under Article 32 in Supreme Court in the form of writs and under Article 226 in the High Court. Article 12 to 35 deals with the fundamental rights and they are negative because it prohibits the state from doing certain things. According to Article 13, if a parliament makes a law that is inconsistent with the fundamental rights chapter, then it is void. Fundamental rights uphold the equality of all individuals and they promote the ideal of political democracy. Coming to directive principles of state policy, Dr. B.R. Ambedkar described DPSPs as novel features of Indian Constitution. They are not enforceable as fundamental rights. If your DPSPs gets violated, you cannot challenge in any court. And Part 4 of the Indian Constitution deals with the DPSPs. Article 36 to 51 deals with DPSPs and they are positive because they enforce the state to do certain things. Directive principles promote the welfare of the community, hence they are societarian and socialistic. Now the debate is which is more important, either fundamental rights or directive principles. According to Justice D.Y. Chandrachud, both together constitute the core conscience of the Constitution. They both should be taken into consideration together. According to Minerva Mills vs. Union of India 1980 judgment, it is said that harmonious relation between fundamental rights and directive principles is a basic structure of Indian Constitution. If we consider the beginning when our constitution came into force in 1950 onwards to 1971, whenever a conflict arises between fundamental rights and directive principles of state policy, fundamental rights are given priority but not directive principles. Let's have a look at the Champakan Dorarajan case in 1951 or the first amendment of Indian Constitution. In 1950, Madras state government gave reservation to the SC and ST in medical and engineering colleges. Champakan went up to the Supreme Court saying that giving reservation to SC and ST is against the fundamental right, Article 14, which is right to equality. Madras state government argued that we are protecting SC and ST and gave reservation according to the Article 46. But the Supreme Court states that Article 14 is the fundamental right and it is enforceable by law, and Article 46 is not enforceable by law as it is a DPSP or a directive principle. Thank you for watching. If you like my video, share and subscribe.